Hi, I'm Paul Marcus from the College of William & Mary, the law faculty, and let me introduce two of my colleagues who are joining us today, Professor Jeff Bellim and Professor Adam Gershowitz. And we're going to be talking about technology. Now with technology, lots of nice questions about what I should buy, where I should buy it, what unit I should get. We're going to be dealing with something a little bit differently. We're going to be talking about technology and the law, and particularly with respect to law enforcement. And Adam and Jeff, what I'd like to talk to you about today and get your sense of what the law is the telephone, not the big clunky phones that we used to have when we were kids, but these little small phones that go everywhere and are kind of mini computers. And secondly, social media, Facebook. So let me start with telephones. Adam, police arrest you, stop you. Can they search your phone? And what does that mean to search your phone?
So it's increasingly a common phenomenon and common problem in the United States to see police searching cell phones of people who they arrest, whether the phone is on their person, in their pocket, in their purse. And the question becomes, are they allowed to do that? And the Constitution obviously doesn't clearly say one way or the other, but there's existing law that's been around for decades that gives police authority to search items on your person as part of an arrest.
Now, Adam, under a particular provision of the Constitution?
Yeah, so the Fourth Amendment allows for the police to search as long as it's not an unreasonable search or seizure. It requires a warrant, but there's a whole host of exceptions to the warrant requirement. One of them is this so-called search incident to arrest doctrine. And case law that's gone back for decades suggests that we could search your wallet or your purse because it's a container. And courts have quickly come to the realization that a cell phone is just an electronic container. And a whole bunch of courts have come to the conclusion that it's permissible for police to search your phone and anything that's on it, whether it's your email, your text messages, your internet browsing, as part of a valid arrest.
Jeff, that can't be right in terms of what the law is. They could look at my email messages. They could look at lists of folks that I communicate with if I'm arrested for a really minor crime. Is that right?
Yeah, well, so Professor Gershowitz is right in this instance that the case law that exists says that you can search someone if you arrest them, and you can search anything that's on their person at a minimum. And so the cases that started out would be maybe a pack of cigarettes. They could look in a pack of cigarettes, but the actual law says you can look in any container you find on the person of someone you arrest. Once the court said that a cell phone is like a container, that was really the analysis. And then the next step was, as cell phones became, as you indicated, like a computer, now the police can go look through your cell phone and look at all of your files and justify that search as a search incident to arrest under well-established case law.
Now, Adam, the Supreme Court has not weighed in here yet. Is it likely too soon?
Yeah, I think this case is coming to a Supreme Court near you sometime soon. I think that the case will reach the Supreme Court in the next couple of years. There's a lot of case law on this, and it's split in that there's a couple of prominent courts that have forbid this practice. They've sort of reached out and said we really should reshape or redefine the law. Most courts have said it's permissible, but given the importance of the issue and how common it's become, and that there's a couple of courts that have tried to suggest we shouldn't be allowed to do this, I think Supreme Court review is fairly likely in the next couple of years.
Jeff, let me turn to you. Social media, the communication through social media has just been revolutionary in a remarkably short period of time. Facebook. I hear rumblings that police want to take a look at Facebook, what entries are. I guess first question is, do they? And what do they want to look at Facebook for?
Yeah, so certainly this is a large issue that's coming to the courts as well. The police are out in front of the courts on this issue, and they are actively looking at social media, so not just Facebook, but other things like Twitter. There was a famous case out of New York recently where the police went after and obtained from Twitter a whole series of records on a Twitter user's usage. And Facebook is obviously a treasure trove for law enforcement because so many people are on Facebook. And in addition to that, and what's so important to recognize in this area is that many people are communicating what they see and what they observe in real time on Facebook. And these people may not necessarily be willing to cooperate with police, but if police can get at their Facebook records without their cooperation. Police really don't need that cooperation, and so accomplices of people who commit criminal acts, members of criminal street gangs who put on Facebook postings like, hey, I can't believe we got away with that, things like that. Police can access that Facebook page, get those statements, and potentially use them in court, even though the person who made those statements would never have cooperated with police, would never have given that statement to the police in the first place. And so I kind of think of Facebook as maybe requiring a little warning along the bottom of the page that kind of everything you post may and will be used against not just you in court, but against your Facebook friends as well.
Adam, are the police in this kind of instance getting a warrant authorized by a judge?
Some Facebook profiles are public in a way that police and prosecutors at the sentencing stage of a case can actually just go ahead and look at that information without ever asking a court for anything. In other cases, what you see are police and prosecutors going through the subpoena route to go gather this information without going for a warrant.
And a subpoena is different from a warrant.
It is. The standard is not as difficult to achieve, and while there's paperwork to be done for it, it's an easier process for law enforcement to go through than to go through the full test and rigor of getting a warrant.
So the world is changing, my colleagues here. I guess I would ask you finally, do you see the Supreme Court starting to weigh in and maybe rein back what the police have been doing, or are they likely to affirm what's been going on? Jeff, let me start with you and then turn to Adam.
Okay, one thing I wanted to add as well is it's not just social media that is at the forefront of the change in what we're seeing out there, but I think the bigger issue is going to be text messages and texting. And so all the things that we discussed with regards to what people are putting on social media, I think is even stronger in the case of text messaging, where people are going to be even more candid than they are on Facebook. And so another kind of realm of where the police are going is to try and get, so we talked about they'll get a hold of a cell phone and look on it, a smartphone. They can get a text that way. They can also get the text through the provider, so Verizon, AT&T can provide text messages to police and have done so already in cases largely through judicial authorized process like subpoenas and warrants. But as Professor Gershowitz talked about, another phenomenon is that if someone you're sending a message to or one of your Facebook friends decides to turn that over to the police, there's really no legal protection against that. And so, people out there with 3,000 friends on your Facebook, you should be aware that you might as well be transmitting your communications directly to the authorities, which may be good or bad depending on what you're up to.
Yeah.
And Adam, the Supreme Court?
Yeah, the Supreme Court, I think, is going to get forced into dealing with these questions just because they're now so common and there's such importance in whether this evidence be suppressed. Unfortunately, the Supreme Court's not particularly well suited to deal with these problems. They tend to be a lot older, a lot further removed from the technology than most people in the United States. And there's a lot of sort of factual questions about how the technology works, how the phones work, what is really available on Facebook or Twitter to the public. That involves a lot of fact-finding the Supreme Court's not well situated to do. It would be great if legislatures would step in here and take a serious interest in this. And that happened in California. It didn't get very far, but most states have not looked at it themselves and taken a serious interest in trying to solve some of these problems before they go to the Supreme Court. I think the court's going to try hard. I think they're going to have to, but I don't know that I have the greatest confidence that they're going to come up with a rule that survives for very long effectively.
Well, Jeff Bellim, Adam Gershowitz, thank you both very much.